Hello, everyone, and welcome to the fourth episode of PrivacyCast. Today marks a very exciting moment for us as we bring on someone who will be taking these conversations forward and shaping how we look at privacy in the episodes to come. I'm joined by Colonel Binoj Koshy, Chairman India, DPO Club, and former CISO at 𝗗𝗍𝗗𝗃𝗃. Sir, it's a pleasure to have you with us, and we're really looking forward to the conversation ahead. So we would like to ask you to formally introduce yourself once for the audience.
I'm a veteran. My name is Colonel Binoj Koshy from the Indian Army, and I have been working on the IT side of the Army for very long. About 32 years of service I have put in. Subsequent to that, I was on deputation with the UIDI, where I did the job of the CISO of UIDI and also Director Technology there. After my retirement, post my retirement, have been an evangelist with the privacy journey of India and have closely watched the DPDP law that has been enacted till now. And I'm happy to be part of this cast, and we hope to exchange a lot of information among us. Thank you.
Thank you so much for that lovely introduction, sir. And it's lovely to know that you've seen this act grow to what it is very closely right from the start, which leads me right into our first question of the day, which is over the last few months, the privacy landscape in India has shifted quite significantly, especially with the rollout of the Digital Personal Data Protection Act of 2023. There has been a lot of movement, a lot of interpretation, and especially, of course, a lot of questions as well, especially from organizations that are trying to understand what this really means for them. So, when especially with the Indian Parliament having passed this in 2025, the Ministry of IT has notified the rules and has pronounced the implementation of the law on 13th November 2025, and about 4 months has elapsed since then. Could you probably tell us a little bit about the status and the directives for corporate with regard to this new law?
Yeah. We are presently sitting on March of 2026. The DPDP law, primarily in India, we follow the provisions of the Act first and then the rule is subsequently followed. The Parliament of India passed the law in, in 2023, and the law became effective after the rules were notified by the Ministry of IT in 2025, precisely on 13th of November 2025. Most of the aspects of operationalizing the compliance aspect for, for the private sector as well as the government sector have been well defined and articulated in the law, in the rules that had come out. Subsequent to that is the period of transition that is expected from the corporates as well as from the government to accommodate this new law. Frankly, if you see the DPDP law, the Digital Personal Data Protection Law of India, is a law that has directed specifically for individuals or of India. Now, from that standpoint, if one sees there is a large amount of transition that is expected both from the corporate, from the individuals, and of course the government. Now, the stand from here is that the data protection board has to be in place. Now, they probably have all the provisions of implementing and ensuring the availability of this law being part of it. Now, as far as the rules are concerned, the administrative rules from 17 to 21 actually talk of bringing in the data protection board. Subsequent to that is the rules 1 2, which is 1 and 2, which is to be effective from 13th of November 2025. Insofar as the operationalization of the law is concerned, though the Ministry of IT did mention that they were very ambitious in implementing this law, however, on 13th of November 2026, that is this present year, we need to have the consent management framework in place, and all corporates are to comply to it with regard to that particular timeline. Now, 18 months was the timeline provided for the complete implementation of the law. So, from that standpoint, if you see 13 May 2027 is the time when the windows are open for implementation. Now, looking at the implementation nuances, first and foremost is to classify the fiduciaries. Now, the notification with regard to significant data fiduciaries, we are aware of what are the guidelines under which they will be classified, will have to come into play. Thirdly, is the second is the aspect of empaneling auditors who would be performing the audit on behalf of the Data Protection Board. So, this notification is yet to come into play. And the third most important aspect is the very fact that the Indian law is based out of consent. Consent is going to drive the implementation of the Act. So, the consent management organizations have to be registered and they need to come up. Now, many of us are aware that there is a litigation in place as of now as we speak. There was a challenge on the constitutional grounds of the Act by a few, which we will discuss a little later. However, that has not provided or has not created any confusion in the way the Act is to be implemented. Now, the matter will be referred to a larger bench. However, there is no such talk of the act itself being abrogated. Primarily, if you see when the Aadhaar came in, the Aadhaar Act was challenged by the Justice Puttaswamy petition that went into the Supreme Court. The Supreme Court actually took about 1 to 1.5 years of time with continuous hearing, with lot of iterations that actually took place, which refined the Aadhaar Act by virtue of the judicial intervention. So, from that standpoint, if one were to observe the practices that is there in the judiciary today, and also with regard to the constitutional provisions of this particular law, the act is not going to go away. Neither has the court. The court has actually refused to stay the act per se. So it may undergo certain judicial review, yet the law will be in place. Even ambitiously, if I were to speak to you, by the times that has been provided in the rule today will be the timeline when the act will be in place. And for the Honorable Supreme Court to do a judicial review of this particular petitions that have come or the law per se is not going to take much time. And I have seen this happening in the Aadhaar iteration that took place, Aadhaar Act iteration that took place. However, just to presume that just because these petitions are there and there's a constitutional challenge on the bill itself, to assume that the law will go away is not, because it was the Honorable Supreme Court which directed the Sri Krishna committee to work out and bring out certain provisions and to bring more clarity into the fundamental rights with regard to privacy is concerned. Yeah, Uttara.
Thank you so much for that very insightful answers, sir. I just want to take a moment to pan into the thing that you mentioned. You mentioned that there is a judicial case that is challenging the digital personal data protection law. So, what should be our interpretation of this matter, especially given that it is sub judice at the moment? And how could the implementers or the effectiveness of the law, how should it be absorbed? How do you recommend that people go about it?
Okay. Now, to bring in a lot of clarity, there is a lot of mist around this particular case that has been filed. First and foremost is the case represented by a petitioner named the Reporters Collective Trust, and they have challenged the constitutional validity of the bill, primarily with two contentions. One is the journalistic access to public information, which will get jeopardized by virtue of the provisions of this particular law. The second is by a journalist who again has got connected to the original case is Nitin Sethi, who is a journalist by profession, who has said that there is a constitutional validity challenge that is there from the DPDP law, primarily because of the dilution of the RTI Act, that is Section 81J of the RTI Act, which earlier had certain provisions of seeking personal information, has been watered down and has been duly amended to cater for privacy while seeking information under the Right to Information Act. Now, the other aspect that is the challenge that has been there is with regard to the government surveillance and the overreach by provisions of the law. Now, there are certain provisions where Government of India, by virtue of Section 36 and Rule 23 of the law, empowers the central government to call for information from any data producer. Now, this probably is claimed by the petitioner as unreasonable and a challenge to the privacy law provisions of the Article 21 of the Indian Constitution. Now, we will not delve into the controversies of it or the validity of the petition or the wisdom of the Honorable Supreme Court, but then these petitions, alongside one more, which also challenges the independence of the Data Protection Board by virtue of the punitive regime that is possible because the board is appointed by the central government. The chairman and the members are selected. Selection of the chairman is by the central government. The members, of course, will also be, there will be a select committee. So, hence, the independence or the executive control with regard to the board per se, Data Protection Board, who is going to become the overseer of the implementation of the act and also with certain adjudication powers. And we know that the punitive penalty provisions that is there of 250 crores. So all this probably has been presumed by the petitioners as a challenge to the aspects of law. Hence, there is certain challenges that is there. However, these cannot be presumed to be a wedge for implementation of this law because the very fact that this provisions of privacy has been now made more formal by virtue of the DPDP law, it actually facilitates corporate interaction even from a global perspective. In fact, in February, the European Union came into India with the confidence that we do have a privacy law akin to many of the other laws in the European Union and, of course, across the globe. So, the essence of privacy being transferred as a fundamental right to the citizen of India has been trusted or ensured by the DPDP law. And so, for corporates to do businesses to ensure the security and safety of the citizens or the residents of India is actually essential. In the present regime, we see a lot of private or personal information lying across the board and without any control. One of the aspects here is the crime that is emanating from these information held by these unscrupulous elements. So we need to ensure that there is a control or proliferation of this private personal information into the into the people who are, presumably hackers or Machiavellian elements who are part of so there is a requirement of this law, and the government absolutely feels that the law is essential and it is in public interest. So the the challenges are restricted to few. However, just because the petition says that it is a constitutional challenge and hence to presume that the law will just get wiped away is not the correct interpretation that we all should do. Thank you. Uthra, back to you.
Thank you so much, sir, for such a well thought out, in depth, well researched answer. Sir, I think there's truly nothing that you don't know, especially when it comes to DPDPA. With that, I would like to ask you one more thing. So now that this law's effectiveness is being heard by this constitutional bench, do you think corporates and compliance organizations should start, investing into solutions, processes, and manpower at this juncture? Is that the best thing for them right now to prepare for this, or should they hold
Yeah.
off for some more time?
Okay. Uh, a well framed question here. Now, this is the question which is being now circulated by many of people who don't want the bill to be in place, or who are not happy with the bill. However, I have been speaking to and interacting with a large mass of corporate heads, privacy champions, privacy evangelists, or DPOs in the country. None of them have been bogged down or burdened down by the very fact that the petition has come. All actions are in place, and there's large amount of investments. If one would see the number of startups that has happened from 13 November 2025 till date on solutions, technologies, processes, IT, softwares, it is actually an eye opener to know that there are people who want to invest and ensure that the bill comes into play. Now, from that standpoint, corporates need not go a step backward. Should not step backward. What actions have been initiated till now, irrespective of what is the judicial review that is happening, should continue in its own way. Now, I'll just tell you why I'm so confident that the bill will be heard by the Honorable Supreme Court and will be provided in a much refined manner for implementation in India and across India and for the corporates all. Justice Puttaswamy's petition was was validated on a three-pronged test. One is the aspect of legality of privacy. Secondly, is the legitimate state's aim of bringing privacy as a right, or even if they were to bring in a solution or a law, it should find and pass the test of legitimate state aim. The third thing is the aspect of proportionality. And the Honorable Supreme Court, in the Justice Puttaswamy judgment that was passed, has deliberated on these aspects: the legality aspect, the legitimate state aim aspect, and the proportionality test. Many of you in the law fraternity would know what exactly I mean when I talk about proportionality as a test. Yes, so I'm not going to dwell into those details. However, the fact that such huge iteration has taken place, and remember, the Puttaswamy judgment that has been released by the constitutional bench had had been passed by a 11 bench judicial table, firstly. Secondly, is that it is the second largest heard case and time spent case in independent India. So, if you ask me frankly, the Constitution of India was drafted over a period of 2 years, 11 months, and about 17 odd days. The DPDP law has been iterated, has been tested, has undergone a lot of testing since maybe around 3 to 4 years from now. If you see from the day the Puttaswamy judgment was filed, the time heard by the Honorable Supreme Court, the time spent to draft the act that came out, the first version of the bill was not approved. The second bill was approved by the Honorable Parliament. Thirdly, is the fact that the rule took almost 1.5 years to be fructified, and for the fact that 18 months is the time that is given. So, if you look at this large amount of time period, this is a landmark journey of the of India. So, Looking at these tests that the Honorable Supreme Court had done, and the very fact that the cases again come up for judicial review, we should presume that the bill will be a well uh, refined or purified as bill that will come up. For corporates to presume and to take a step backward that the law will find it will be watered down is a perception that one should not do. Also, for the fact, if you look at it, if you just leave aside all the judicial aspects of it, if one reads the aspect of privacy and if one reads the bill from that point of view, we see that it is for the good of India. It is for the good of the residents of India. It is more of empowering a citizen of India. So, hence, whatever investments that corporates are doing, I feel personally that one should augment those and ensure that we meet the timeline, irrespective of a delay that may happen due to the judicial. And the beauty of the Indian democracy and the aspect of Indian law is that we have a provision of judicial review, which is a constitutional right provided to we the people. Hence, the ownership of that judicial review is taken by the Honorable Supreme Court, and the petition filed by these petitioners actually landed up in a two-bench judicial bench. The Honorable Supreme Court had decided that it is a constitutional bench that will now review. Probably, we don't know the strength, but it will be more than 3 to 5 judges learned judges who will be reviewing the petition. And whatever is the um, outcome of this will be well utilized. And today, like in the case we rely on our Aadhaar ecosystem, it was primarily because of the judicial review that the Honorable Supreme Court conducted that has made this law so well and being used by all. In fact, Aadhaar touches each and every citizen from birth to its death. So, with that as the conclusion, I would like to mention and caution the corporates to go ahead with whatever implementation, irrespective. It is actually bringing in privacy hygiene, it is bringing in privacy best practices. We are also bringing in confidence from the our global counterparts when such a bill will come into play. Thank you.
Thank you so much, sir. I think we've all had a lot to take away from this lovely conversation. But before we close, sir, I just want to ask you one thing. So, if you were a corporate organization right now, keeping in mind this scenario, what is the first thing that you would do if, say, you haven't done anything so far? What is the first thing that you would urge all corporates to first do with this situation?
I'll answer this question from what I learned from the corporates. Many of the good corporate houses have already done their gap analysis. Present stage in which the corporates are in, they are doing POC, evaluating softwares that they can accommodate to ensure that the privacy is built in and to comply with the law that is there. Most important aspect which most of the corporates are doing is investing into training, awareness, and also upskilling or unlearning and learning aspects of privacy, because the journey of privacy has already been undertaken by the European world, and many of the corporates of India have actually complied to GDPR by its own will to accommodate businesses that was demanded by the GDPR regime. Hence, corporates are already in the play. I only suggest that those who have missed the bandwagon should actually get into it and start using services. And mind you, there are large amount of solution providers, consultants, uh, corporate houses who have jumped into the business of providing privacy or hand holding of privacy for the corporates. So that is my last word.
Thank you so much, sir. I think this brings a lot of clarity to a space where there's still a lot of ambiguity and really gives organizations a clear direction on how to move forward. And thank you so much for joining us today. And thank you to everyone who is tuned in. We'll be back next week with another episode of Privacy Cast with Sir. And until then, take care and stay privacy aware.